All right, let's dive right in. If you've ever been stuck in maddening traffic, you know exactly how valuable a good shortcut is. But what happens when that absolutely crucial shortcut happens to be someone's private property? Welcome to this explainer. Today we're going to unpack a fascinating, multi-decade Supreme Court dispute over a very, very busy stretch of road. We're using this case to uncover the strict constitutional limits of government authority over your private land. So, if you've ever wondered where the government's power to regulate ends and their obligation to cut you a check begins, well, you're in exactly the right place. Think about this for a second. What actually happens when a city simply declares that your private land now belongs to the public? This single question anchors a massive legal battle testing the constitutional protections that shield your home, your land, and your business from government overreach. It's a story about traffic, property titles, and a really heavy stroke of a legislative pen. Section 1. The Private Road Dispute, or the Battle for Marcos Alvarez Avenue. Okay, so the story of Marcos Alvarez Avenue begins all the way back in 1959. Two corporations, Southridge Acres and Top Service, owned a network of 7 parcels of land that made up this avenue. And for decades, starting in the 1960s, they acted exactly like true owners. Other landowners and developers who needed to use this road for access actually had to secure right-of-way authority from them and, pay them compensation. They owned it, they maintained it, and they charged for access. And that was the status quo, right up until 1997, when the city of Las Piñas suddenly stepped in and changed absolutely everything. Which brings us to Section 2, the City Ordinance. Striking the gavel on Ordinance Number 34397. Seeking a quick solution to heavy traffic and severe wear and tear from motorists traveling back and forth between Las Piñas and Cavite, the city enacted a sweeping new law. It boldly stated, the whole length of Marcos Alvarez Avenue is hereby declared public road. Literally with a single stroke of the pen, the local government completely withdrew this privately owned avenue from the commerce of man. Think about that. They didn't buy it. They didn't ask for it. They just simply declared that because the public was using it heavily, it now belonged to the public. Naturally, this immediately set the stage for a total David versus Goliath scenario. On one side, you have the landowners. They are strictly defending their decades-old property titles and their lawful private ownership. On the flip side, you have the government, the city of Las Piñas, who, to be fair, was driven by a genuine desire to serve the public welfare. They're seeking traffic relief and trying to maintain a road that had basically become a vital link for the community. So it's this classic clash, right? Private rights head-to-head with public convenience. Section 3. Police Power versus Eminent Domain. The Constitutional Balance. Before we look at the verdict, we really need to distinguish between two massive powers of the state. First up, police power. This is the state's right to regulate or restrict how you use your property to promote public welfare. Think zoning laws or maybe demolishing a building that's on the verge of collapse for public safety. Because it's just a regulation, no compensation is required. But then you have eminent domain. This is when the state actually takes or appropriates your private property for public use, like taking land to build a highway. The Constitution explicitly states that if the government exercises eminent domain, they absolutely must pay you just compensation. The city of Las Piñas argued they were just exercising police power. The landowners, they argued this was eminent domain, basically wearing a police power disguise. The Supreme Court has this brilliant way of illustrating property ownership. They call it a bundle of rights. You have the right to possess your land, use it, exclude others from it, and dispose of it. Now, in the exercise of police power, the government might restrict how you use your property, sure, but they don't take any of those rights away for their own benefit. But when the government appropriates the bundle, when they take those rights away entirely to apply them to a public purpose, well, that is eminent domain. And when that happens, you have to be paid. Moving on to Section 4, the subdivisions argument. Enter Royal South Subdivision. So the plot thickens here because a third party enters the ring, a subdivision developer whose interests were later taken over by Banco de Oro, or BDO. Their Royal South Subdivision residents heavily relied on Marcos Alvarez Avenue. So they intervened in the lawsuit on the side of the city, basically saying, hey, the ordinance was a valid exercise of police power. But they also brought a completely new weapon to the fight. They pointed to a law called Presidential Decree 1216, claiming that under subdivision laws, private owners are actually required to provide adequate roads and automatically donate them to the city. Therefore, they argued, ownership of the avenue was automatically vested in the local government anyway. Well, the landowners, Southridge Acres, did not take this lightly. In retaliation against the developer, they slapped a lis pendens on all of the subdivision's titles. Now, what's a lis pendens? It literally translates to a pending suit. It is a formal notice inscribed directly on a property's certificate of title. It serves as a blaring warning to the whole world that the property is tied up in litigation, and anyone who buys it does so entirely at their own risk. This was a massive move. It effectively froze the developer's ability to smoothly sell their subdivision lots while this whole lawsuit dragged on. Section 5. The Supreme Court rules. The final verdict. When this tangled web finally reached the highest court in 2021, the justices had to meticulously untangle this mess of public convenience and strict constitutional rights. And their rationale was crystal clear. First, they ruled that just because the public has been tolerated to use a private subdivision road, that does not somehow magically strip it of its private character. Second, addressing the developer's argument, the court cited previous rulings stating that private owners cannot be forcibly compelled to donate their property to the government. Therefore, the conclusion was absolute. City Ordinance Number 343-97 is unconstitutional. This quote from the Supreme Court is basically the hammer dropping. They wrote, "The taking of SRA's property without just compensation amounts to confiscation, which is beyond the ambit of police power." This powerfully reaffirms that boundary we discussed earlier. The government absolutely cannot bypass the constitutional requirement of paying just compensation simply by pointing to traffic issues and labeling a land grab as a routine exercise of police power. However, the court also had to do a bit of judicial cleanup with the subdivision developer. They ordered the cancellation of the lis pendens on BDO's titles. Why? Well, because a lis pendens is only meant to be attached to the specific properties that are actually being fought over. The property in dispute was Marcos Alvarez Avenue itself, not the individual residential lots sitting inside the Royal South subdivision. So the court ruled that it just wasn't necessary to tie up the developer's unrelated property to protect the landowner's rights to the avenue. Section 6. Your property rights. Why this matters. So you might be wondering, why does a decades-old dispute over a road in Las Piñas matter to you? Well, the ultimate takeaway from this saga guarantees that if the local government wants your private land to utilize as a public road, or really for any public use, they can't just pass a law and take it. They must legally acquire it through one of three strictly compensated or voluntary methods. Number 1, you choose to donate it. Number 2, the government purchases it from you through a standard sale. Or number 3, they exercise true eminent domain, expropriation, which strictly mandates the payment of fair and just compensation. There are simply no shortcuts. It really all boils down to this. If public convenience always outweighed private ownership, would any of our property truly be safe from being declared public? It's a fascinating constitutional boundary to ponder the next time you hear about an urgent infrastructure project popping up in your own neighborhood. Thanks for joining me on this explainer, and I hope this brought some real clarity to your constitutional rights.